And on the phone, I have Andrew Stoltman, attorney for the two potential Prince heirs we've been speaking about. Andrew, what is the issue with the DNA testing?
Well, the issue is pretty simple. Look, we don't have a problem with the 742 other people who've come forward claiming to be heirs being genetically tested. But under the Minnesota Parentage Act, in a situation like our situation, where you have an individual, Duane Nelson, that has listed John L. Nelson, Prince's biological father, as Duane's biological father, the Minnesota Parentage Act does not require DNA testing from those folks. So to the extent you have the right dad listed as the biological father, in this case we do, we submitted it in that birth and death certificate of Duane Nelson, we don't have to submit to it. And that's not Andrew Stoltman saying that. That's in the Minnesota Supreme Court. So we're going to ask the judge in this case to abide by the decision by the Minnesota Supreme Court.
Why does that have to be filed as such? Why doesn't the judge already abide by a Supreme Court decision?
Well, we're simply telling him, basically reminding him that this is his requirement. And look, judges can decide what they want to decide, but given we have controlling law, we think we're standing on pretty solid ground on this issue.
Given those two you feel do not necessarily need to go under testing, are there others who should?
Yeah, absolutely. I mean, for example, the gentleman who has claimed to be his biological son, I think he has to. I think he has to undergo the testing. Some of the crazies and kooks who have come out of the woodwork claiming to be Prince's long-lost brother, son, whatever it may be, I think those people have to be tested. We have a vested interest in keeping people who are not genetically or biologically related out of the inheritance.
And Andrew, the media is pressuring to cover future hearings regarding the estate. Can you tell me what's going on there?
Yeah, the press really wants to get in this courtroom. They want to videotape it. They want to provide live feeds. And I understand the public's curiosity in this case because it is a fascinating case. But, we're dealing with, in this case, one of my two clients is a minor. And what we've noticed over the last 25 years is that when cameras go in the courtroom, it tends to turn into a circus and look no further than the O.J. Simpson trial.
Andrew,
so I understand.
Yeah, we get it. I mean, we've been through some of these. And yet, some people feel that the Sunshine Acts are valuable and that people do learn a little something by being witness.
I don't think there's any question that in one sense, I mean, sunlight is the best disinfectant. But that being said, when you're dealing with minors, when you're dealing with people like VN, in this case, my client, you just don't want the cameras in their face.